Hi guys, it's Kathy. I hope you're doing well. So, we're going to start today in Judge Stevens' courtroom. They had a trial. We're not watching the trial. I'm sure other channels have it, so you can go watch it. But it's just nice because the reason why we're watching it is because we don't get to see a real sentence very often. We get to see, 4 years or 2 years or 30 days. Um, I mean, sometimes we do. Remember that lady? Oh, I gotta find her. She got 400 or $4,000 in contempt charges because she kept swearing at the judge and he kept giving her more and more and more. Anyway, um, we get to see a real sentence, but it's a complete sentence, point blank, period. But he doesn't give the sentence. This judge doesn't give the sentence out. What we need is power of the people. Give the proper sentence out. So this is the guy right here, the defendant. We don't really get to see him.
20-34550, the state of Texas versus Jovan Ivan Neveau, who is present with his attorney and the state's attorneys. The court has received a
No, I
message
have not.
from the jury that the jury has reached a verdict in the punishment stage of this trial. And I'm going to ask the bailiff at this time, please bring forth the jury and we will receive the verdict. Thank you. Oh,
Monica.
we have all of them. Thank you very much.
I would like to know who this guy is right here, but I don't think I find out. This is the prosecutor.
The record shall now show that the jury is in the courtroom. Ms. Anthony. Yes. You are the jury foreperson. And we have received a message on behalf of the jury that the jury has reached a verdict in the second or punishment phase of the trial. Is that true?
Yes, sir.
Is this verdict a unanimous one? That is one that is agreed upon by all members of the jury?
Yes, sir. Yes.
Do any of the members of the jury disagree with your foreperson's representations? No disagreement is obvious and apparent, and it does indeed appear to be unanimous. As before, if you would be so kind to pass the documents to the bailiff, you may be seated. I will review for proper form and publish the verdict. And the defendant shall rise. In cause number 20-34550, the state of Texas versus Jovan Ivan Neveau, we, the jury, assess the defendant's punishment at confinement in the institutional division of the Texas Department of Criminal Justice for a term of 60 years. This is signed by the jury foreperson on behalf of the jury. It is received. It is made a part of the record for all purposes, and you may be seated. Ladies and gentlemen of the jury, I have received your verdict. not only finding the defendant guilty of the charged offense of murder, but assessing the punishment at 60 years confinement in prison. At the beginning of this trial, I placed all of you under a number of instructions. At this time, I am releasing you from those instructions previously given to you. Once you are discharged, you are released from your oaths of secrecy. You are free to discuss this case in your deliberations with anyone. And you are also free not to discuss the case. And you have every right to maintain your silence unless otherwise ordered to do so by the court. Once you are discharged here in a few moments, I have to take up some matters with the lawyers, and they will be released. And they always like to get input or feedback from jurors if you're willing to speak to them. It helps them become better lawyers. And I think that they can also answer any questions if they want to, that you may have concerning matters that you were involved in here. It is never a comfortable situation to make judgment decisions on others, fellow humans. But it's the way the United States of America works. We, the people, is the way it begins. We, the people, in order to form a more perfect union right out of the box, establish justice. That's the first thing it states in the Constitution. And the people who formed this country, they didn't know us, but they were speaking to us. And in the job that you have, when someone requests a trial, which is a constitutional right, you have to have good, fair people make the decision. And it's never an easy situation in this court. And I've been doing this for over 40 years now. And as a prosecutor, as a defense attorney, and now as a judge. And dealt with one of the most prominent cases in the history of this country. But it is important that good people make good decisions, following the law, working together. And that's the way it works, we the people. And I hope to have the honor to work with you again in the future. And until then, may God continue to bless Jefferson County and her citizens. And you are excused. Thank you very much. Ellie is going to have documents for you if you need it for work or school or other purposes, and she's right there at the doorway. Also, and alternates, thank you very much for your time. We have been using alternates a lot in this past year or so. And I want to thank you for your valuable time and hope to work with you as well in the future. Thank you. All right. Is there any legal reason why formal sentencing and rendering of the judgment should not be pronounced at this time, state of Texas?
No, Your Honor.
And defense.
No, Your Honor.
Jovan Kavan Nevo, you came before this court and a jury, entered a plea of not guilty to the offense of murder as set out in the indictment. The evidence was submitted and the jury was charged by the court. After deliberating, The jury returned a verdict finding you guilty of this first-degree felony of murder. Thereafter, evidence was presented on the matter of sentencing of this first-degree felony, and evidence was submitted. The jury was charged. After deliberating, the jury returned a verdict assessing your punishment at confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 60 years. Finding nothing legally to bar the sentencing here, it is the judgment of this court that you are guilty in cause number 20-34550
Monica.
and shall be
Thank
punished in
you. We
accordance with the
appreciate it.
jury's
Thank
verdict.
you.
Anything to be said by the defendant? No. Having nothing to say by the defense, it is therefore the order of this court that you, Jovan Kevon Neveau, who has been adjudged guilty of this first-degree felony of murder as indicted in this cause number 20-34550, and whose punishment has been assessed by jury verdict at 60 years imprisonment in the Texas Department of Criminal Justice's Institutional Division, you shall be delivered by the sheriff of Jefferson County, Texas, to the director of the Texas Department of Criminal Justice's Institutional Division, or any other person legally authorized to receive such convicts, where you shall be confined for 60 years in accordance with the laws governing the Texas Department of Criminal Justice's Institutional Division. Next, before I finalize matters, Article 42.08 of the Texas Code of Criminal Procedure provides the law surrounding cumulative or concurrent sentences. Cumulative being stacked or consecutive versus concurrent sentence. The defendant is
Kelly, thank you so much. Thank you.
currently serving a life sentence on two cases, 2 life sentences and 2 aggravated robberies. And he was placed on deferred or unadjudicated probation in
That has to hurt, Judge. Judge, that has to hurt. Judge, you let him out. You let him out. And he murdered someone.
in both of those cases, which are 18-29090 and 18-29093 cause numbers. He was placed on probation on July 15th, 2019 in this court for 10 years deferred or unadjudicated probation for those 2 offenses of aggravated robbery. Thereafter, the defendant is alleged to have was indicted for the commission of this murder in 20-34550 that the defendant has been found guilty today and sentenced to 60 years imprisonment. On April 15th, 2020, which was
Thank you,
about
Kelly. Thank you.
10 months, 9 or 10 months after the defendant was placed on probation for those 2 aggravated robberies. Motions to revoke unadjudicated probation were filed by the state of Texas on June 4th, 2020, alleging that the defendant's probation should be revoked, and the court found true allegation number 1 in the motion to revoke probation, that the defendant committed the offense of murder while on probation on or about April 15th, 2020 in Jefferson County, Texas, which was represented by the new indictment that was filed on the indictment that was filed on June 17th, 2020, for which the defendant was found guilty today. And on or about May 4th, 2020, two, 2022, a hearing was held on the 2 motions to revoke probation in the aggravated robberies that the defendant was on probation for. And the court found true that the defendant violated his probation by committing the offense of murder. And I believe also by failing to provide verification of performing community service hours, which are allegations 1 and 2 of the motions to revoke probation in each case. The court found there was enough evidence to support the revocation. The defendant's deferred or unadjudicated probation in those 2 aggravated robberies were revoked, and he was found guilty of those first-degree felonies and sentenced to life imprisonment on each of those cases to run concurrently. Under Article 42.08, that provision under the Texas Code of Criminal Procedure provides for cumulative or concurrent sentencing instructions. And what says the parties as to how the assessment of this sentence should be applied concurrently or consecutively to the 2 prior convictions of aggravated robbery? What says the state?
Judge, I'm going back and forth on this when we were coming up on trial, what I was going to do at this point, if it came to this point. I then went back and was reminded of that original robbery where some people were shot, and the group that Mr. Nevo was with, and I remember putting each of them in prison over the years and how that's quieted down the neighborhoods and the apartment complexes, and the robberies have gone down. Because of his young age, I that's what put me on the bubble. But due to the fact that going through all this and listening to the facts of the case and listening to the facts of the previous case, we would ask that the judge run them cumulative and stacked on top of the other.
Mr. Matuska, on behalf of the defendant, what do you want to say? Go ahead.
Yes, Your Honor. Because of the weight of the conduct of the murder, I believe the court considered that greatly in its decisions during the revocation of the robbery cases. And that's relevant in the court's decision at that time. But I just want to point out to the court that in those cases, the court was very generous in granting Mr. Nevo the deferred adjudicated probation, in large part due to findings of the gunshot residue testing, which showed that the other actors were the shooters, and Mr. Nevo was involved, but not a direct shooter in that case. This is a similar case. No allegations were made that he was a shooter, and Because of that and because of his age, Judge, we're asking the court to sentence this consecutively. Thank you.
I'm sorry,
Oops.
Second concurrent.
did you say?
Concurrently, Judge.
Okay,
I apologize.
that's all right.
Thank you.
I understand what you intended.
Yes, sir.
And now, Mr. Naveau, you have a right to be heard at this time. Is there anything you wish to say?
Yes, sir. I don't feel that it should be learned consecutively because I was sentenced for the probation for the murder charge. It's not being guilty, it's not guilty time. You sentence me to life in prison. I would like it to remain concurrently. If
Anything else? Is there anything else at all?
Sir,
No, you've had a long time to think of this. Well, you would say, oh. Mr. Naveau, you were placed on deferred or unadjudicated probation. And this court stuck its neck out on that one. Because those were two violent crimes that were committed. First degree felonies. But the court deferred any finding of guilt and gave you another chance to show you were not only remorseful, but you had learned from your mistake. Not 10 months later, between 9 and 10 months later, you're involved in this murder. After it had to be fresh in your mind that the court, these were serious proceedings. We make a big thing about this to impress upon defendants that when they get in this court, this is justice. And if you're going to be placed on deferred or unadjudicated probation, you have to follow the rules. And these aren't anything special. These are the terms and conditions of probation are essentially what I have to follow. That you're placed on probation. Everybody has to follow, not commit crimes and make the correct decisions. You elected to pal up with a bad crowd and a person. This was also a home invasion. Somebody's home, which is their castle, is invaded violently by a group of people. And the victims in this case didn't have a chance. I mean, they were completely subdued and there's nothing that shows anybody was fighting back. And y'all had all the power and control. And a person is shot and killed. So we have now 3 violent crimes that you were charged with and held responsible for. After we had to make a big impression on you, it should have been that you had a up to a life sentence to be paid for by those probations that you were on. So the court had its motion, presided over the motion for the unadjudicated probation violations. And on May 4th of 2022, on each of those 2 cases that you were on probation for, those first degree felonies, aggravated robberies. The court revoked your probations, found you guilty, and sentenced you to life in prison on each of those cases to run concurrently with each other. You were sentenced, the life sentence that you received were for the aggravated robberies. Those were for the punishment that you had received, the probations that could be revoked for failing to show up for an appointment with the probation office. That's simple. Failing to follow community service. That's simple. But yet, what you were revoked for was for committing the most violent crime that we know about, and that we have on the books, and that is the taking of another human life. After human life was threatened on those other two occasions that you were placed on probation for on the aggravated robberies. So you were incorrect, sir, on stating that you've already been sentenced on this. No, you were sentenced for the aggravated robberies. You hadn't paid the price on that yet. But when you were revoked, you're going to interrupt me? You'll have a chance to respond in a moment. Let me finish. When you were revoked for this, you were sentenced on the aggravated robberies. You weren't sentenced on the murder. You have to pay a price on each aggravated robbery that you did. Now you have to pay a price on the murder. If it were otherwise, if the law was otherwise, then what would, if somebody wanted to really commit a string of crimes, they just say, I'm going to do all for one, and I'll just do it all at one time, and I'll commit a string of crimes and create chaos around the city, and I'll just be punished for one. That's not what we do. We are all held accountable for each crime. And sometimes we accumulate, and sometimes they're concurrent. Violent crimes have victims for each particular crime. And they always want to know, where's justice for me? Because my life was in jeopardy on these aggravated robberies. I had no power. The person with the firearm and threatened me and took my property, they had the power, not me. That's not right. That's not the way it was intended by our Creator or the laws of the United States. But yet, not shortly thereafter, you have hooked up with the wrong crowd, and another person's life is not only placed in jeopardy, but this time it's taken away forever. A third person and their family have been violated and victimized by your acts. You knew when we placed you on probation that this was serious. You knew your probation could be revoked. And you had to know that being involved in violent crimes gets the attention of the authorities and is handled severely. One other thing. Here you are with all of this, now in history and behind you. You have an opportunity to make a statement. You've made a statement. You've had to have had a long time to think about it if you got to this point. You had to have a time to think about what you would say when your probation was revoked after the motion was filed. You know that was going to ultimately come about. And here you are. And with 3 violent crimes, 3 sets of victims and families that have to endure the victimization and the taking of a human life. I have not heard you say, I regret what I did. Once. I am sorry. What kind of person fails to say that at this point?
I never did it.
All right. Anything else?
Yes.
You have anything else?
Yes, sir, Your Honor.
Stand up. Stand up. Go ahead.
My probation got violated.
No,
Two
no,
crimes.
hold on. Your probation didn't get violated. You speak just like all the convicts. You're institutionalized. No. You violated
I violated.
your probation.
My
Yes,
probation.
and then you have to pay a price for your
Yes.
actions. That's what
Yeah.
happened. Okay.
I violated my probation,
Yes, sir.
as you said. Well, 1, murder. 2, community service. I pled not true to it. Community service technical violation. The murder charge, I was never found guilty. Of the murder charge, which I violated the probation due to it. Which read a case, Flores versus State, that you cannot be convicted of the charge or found guilty on probation to final conviction. All right. Community service is a technical violation. Life in prison is excessive punishment in community service. I got found guilty today, 2025, 3 years later. But I was already guilty in 2022, which I found true. It's not true. It's not true. I never once said anything because I'm innocent and I did not do it. I was not there. I do not know anything about it. When I signed for the probation, I pled guilty because I was guilty. I was guilty. I got probation. I allegedly caught a murder charge. Allegedly. Was never found guilty of it, but child found me guilty of it. I pled not true to it.
Anything else?
No,
All right. Uh, your probation was revoked and you were held accountable for the revocation for the aggravated robberies. And you pay a price for each crime you commit. And this is the price that you're going to pay, is what the jury assessed, the punishment of life in imprisonment. And it is in the discretion of the court as to whether the judgments in the subsequent conviction, in this case, would run consecutive or concurrently with the 2 prior convictions of aggravated robberies from the motions to revoke probation that the defendant was placed on earlier, found guilty, and sentenced to life imprisonment. Stand by just a second. And the court has hereby formally adjudged the defendant guilty of the offense of murder, as he has been found guilty of in 234550, and is hereby not only adjudged guilty, but now sentenced to 60 years confinement in prison for this murder case in cause number 20-34550. The defendant shall be transferred to the custody of the Texas Department of Criminal Justice for the purposes of serving this 60-year sentence that is ordered to be served consecutively to the 2 life sentences that was assessed for the aggravated robberies he earlier was charged, convicted, and
Where are you, Jim?
sentenced for. And the judgment shall reflect that these sentences again shall run consecutively, and at the conclusion of the sentences
Thank you,
that
Jim.
he serves
Thank you.
on the earlier aggravated robbery convictions, then he will begin and serve his sentence when those aggravated robberies are concluded for sentencing purposes. Then he will begin service to serve out the sentence of 60 years imprisonment
Yay,
assessed in this
yes.
murder case. Do you understand what has happened today, sir? Okay. Anything to add from the state or the defense?
No.
All right. Make sure you have a right to appeal this, and the appeal documents are filled out as soon as possible for Mr. Naveau.
Yes, sir.
Anything else to bring up? If not, we are in recess. Thank you.
There we go. We got to see a real sentence. A sentence the likes we've not seen in a long time. Now we're going to go here. And this was a while ago, so this sound should be fine. Yeah, that's a long sentence too, JK. poor Jude and Terry have gotten long sentences from me. 10 months. All right, Victoria is in trouble. I should press play. That would be better, right?
Yes, thank you so much. Thank you so much for being here today. Thank you for your time. My name is Victoria Hoffman, and I'm licensed to practice law in the state of Texas. I got my license in 2005, and I graduated from the University of Houston Law Center. I have been practicing law for the last 11 years when this complaint was filed. This complaint was filed by Ms. Jahangirova, who was actually invited by me to assist with interpretation.
I can't stand. I am literally playing a freaking YouTube video. There is no reason half of you cannot hear this. I don't understand why this does this. No, none. No reason why you can't hear this. None. Nope, we don't get to see Victoria, guys. Hold on. I gotta go back further in time. I think it's people who don't have stereo set up on whatever they're listening on and only have mono don't hear some of these videos. that looks good, but it looks so long. Hold on, that one's too long. I need a shorter one. Elaine, no, Aline Glassman. Let's watch Aline Glassman. Oh, but I had the other one. Anyway, that lady we just saw, she is still a lawyer in Texas. Don't worry. So now you know the verdict.
Morning,
All right,
Ellen Glassman.
hold on.
Pro se in this matter. I would like to provide some context for some of the more unusual issues.
I need to hear if anybody. Can I hear her?
Can I ask you, Ms. Glassman, to move a little closer to the microphones?
Hold
Can
on.
I ask you to move a little closer to the microphones for two reasons. I'm hard of hearing, and secondly, the proceedings are being videotaped. And
Is
so
that better?
yes, thank you.
Okay, once she said, "Is that better?" Is that
I
better?
presented a number of issues in my appellate's brief. First, may it please the board. My first position as a practicing lawyer was with Houston Legal Foundation, now Lone Star Legal Services. That position began in 1969. In addition to practicing,
You know how they said even lawyers always get lawyers for themselves, right? We watch these disciplinary hearings for these lawyers in Texas, and they don't all represent themselves, but the majority of them just represent. Victoria, what we just saw, she was representing herself. Glassman here, she is representing herself.
in district courts, family courts, which we then called courts of domestic relations, county courts at law, justice court, and occasionally before administrative agencies. My responsibilities included training and supervising third-year law students and licensed attorney volunteers assisting with all aspects of our client representation. My title, after I had been a staff attorney, then a managing attorney, was Director of Professional Education and Staff Training. My status at University of Houston Law School in teaching the weekly seminar that was part of the clinical legal studies curriculum was Adjunct Assistant Professor of Law. My early experiences as a lawyer may explain my awareness of the various jurisdictional criteria in different groups of courts and the importance of proper screening, training, and supervision of volunteers. Among the topics covered in the weekly seminars of my course was the necessity of sufficient pleadings, proof of jurisdiction, and that all allegations must be supported by proof in order to achieve recovery. That was a while back. But about 10 years ago, I was senior faculty teaching paralegals in an ABA-approved paralegal training course, and those criteria had not changed. Now there is case law, Department of Parks and Wildlife v. Miranda, which has provided a modification as to proof of jurisdiction in district courts. That modification is explained in Department of Parks and Wildlife. It relates to district courts because they are courts of general jurisdiction. There are no cases on this point that address the question as to statutory courts or administrative tribunals. To understand some parts of this appeal, it is helpful to separate the relationship between the State Bar as a public corporation created by
I just looked up the ending on this one.
special statute and Commission for Lawyer Discipline, a committee of the State Bar created by specific language in the State Bar Act. The relationship between the public corporation and the administrative agency can be confusing. The State Bar is created by special statute and is within the Texas Business Organizations Code for purposes of the way it is run. It is a Texas nonprofit. Books and records of Texas nonprofits are open to the public. Some of the books and records of Commission for Lawyer Discipline are exempt from that requirement. Commission for Lawyer Discipline is governed by the Texas Supreme Court, but only for administrative purposes. Some of you may be familiar with 501c3 charities, educational organizations. You probably give them some of your tax
Thank you,
deductible
Dwight.
contributions.
Thank you.
I am not, claiming that the state bar is a charity. I think it's a C6, but it is within one of the federal standards for exempt organizations. Fundamental vital facts have been disregarded or disposed of rather cavalierly in this matter. They've been distorted by Commission for Lawyer Discipline and by the evidentiary panel 4-6, which is part of the grievance committee of State Bar Region 4 with regard to evidentiary proceeding H005 1132998 and prior proceedings in Harris County Probate Court 1, as well as the 14th Court of Appeals. Those are the background matters that gave rise to this appeal. Disregard of these vital facts has produced confusion, absence of due process, avoid rendition, avoid judgment, and several other significant mistakes, errors, and distortions. Now, probate courts are statutory courts. All statutory courts and administrative agencies in Texas are created by specific statutes. And when you go into a statutory court or before an administrative agency, you must prove jurisdiction in personam and subject matter.
Ms. Glassman, you raised those arguments in the Houston litigation, did you not?
I certainly did, every step of the way.
And the Court of Appeals held against you.
Oh, wait a minute.
In the
Please
14th
repeat your
district.
question.
Yes, the 14th district rejected your arguments that the probate court had no jurisdiction, did it not?
Well, yes and no. They never addressed the fact that this was from a statutory court.
But they addressed your position and affirmed the case below. Did you then seek Supreme Court review?
I did.
And it was denied.
That is correct.
And then you sought rehearing in the Supreme Court also in 2011.
Yes,
and
all
that
of that
was
is
denied.
correct.
So that your arguments concerning jurisdiction of the probate court have been rejected with finality in litigation that you participated in and that ended in 2011?
That is not my understanding of what a Supreme Court decision not to review means. They decide which matters they're going to review. There has been no holding on this question. There has been no holding on judicial admission.
Is it your claim that the Houston 14th Court had no jurisdiction?
Well, if the judgment from the probate court was void, everything that follows from it is void. But I did submit the appeal, and the 14th, the problem is the judgment from the 14th court is not predicated on any authority at all.
Is it your position
Writing.
that the panel below had no jurisdiction?
Are we talking about probate court?
Disciplinary proceeding.
All right. It's the same issue, but it comes up repeatedly.
Is it your position it had no jurisdiction?
My position is that they had the panel, the evidentiary panel had the jurisdiction to hear the matter.
All right.
That's all they had. They never achieved subject matter jurisdiction to adjudicate issues, issue grant recovery, or issue judgment. That is what subject matter jurisdiction is.
Is it your position that this board does or does not have jurisdiction?
I just put out a Sovset video 7 hours ago, right? It was so crazy. This woman walked into a courthouse and found like a 17, 18-year-old boy, maybe 19, I don't know. He was just so young, who had a traffic violation. I don't know what traffic violation. And talked him into, recruited him into her Sovset movement right then and there. And then he walked out of the courtroom. So she gets in trouble for practicing law without a license. So she's in court. She brings a huge following of Sovsets with her. So it's a Sovset hearing with like 20 Sovsets in the gallery. And they're all yelling at the judge the whole time. Yes, CJ remembers it when I first played it in 2023. It's freaking crazy. She says there's no jurisdiction there, too.
I don't know the answer to that.
You do not take the position that this board is without jurisdiction.
I don't know the answer. These issues I cannot find any case law on any of this. I found no Board of Disciplinary Appeals opinions, and researching Board of Disciplinary Appeals opinions is not like researching in the appellate courts and the Supreme Court. I went through many of the opinions. I have found none that address any of these issues. Now, either no one has appealed based on these points, or the cases exist, but I did not find them. I did ask opposing counsel for appellee. She has no cases.
Let me be more clear with my question. In your brief on appeal and in your supplemental brief,
14th court?
to this board,
To this board,
and in your supplemental brief and in your reply brief,
yes.
you have not expressed the view that this board has no jurisdiction, have you?
No,
And
but my
you're not today arguing that this board has no jurisdiction.
I cannot
Answer the
create
question.
or deny jurisdiction.
But you cannot,
It's a
but
question of law.
you can answer the question whether you are taking that view in your argument today.
I am not taking a view on that one way or the other. I don't know the answer.
All right.
If the judgment below is void, it's void. If the probate court judgment is void, and according to Dubai Petroleum, a judgment that is void stands on the docket ready to be tried. In the probate court, the appeal was a collateral attack. A collateral attack is not res judicata of anything.
Ms. Glassman, let me just make sure I'm hearing you correctly. Let's assume the judgment in the probate court was void, then the appellate court, that should have been declared by them to be void, and they did not do that. Is that correct?
That is correct.
And that seems to me to be a rejection of your argument, and the same seems to hold true here, that if the disciplinary board hearing, the grievance committee hearing was void, and you're not contesting we don't have jurisdiction, it's up for us to make that decision, is it not, to determine if it was void, in your view?
That's my understanding, is that any tribunal can declare any void judgment void, but I'm in uncharted territory here.
One of
I
your,
couldn't find any cases.
a substantial part of your briefing, as I understand it, is an assertion that below in this disciplinary proceeding, there was no proof of a large number of jurisdictional facts.
That's correct.
And are you familiar with the principle of presumption of regularity in proceedings?
I am somewhat familiar with it, but there is a specific requirement that there be proof of subject matter jurisdiction, and Assistant Disciplinary Counsel clearly knows that. He tried 3 times to prove subject matter jurisdiction, but all he proved was in personam jurisdiction, and then he called it subject matter jurisdiction. Now, to prove subject matter jurisdiction, they have to prove standing, a justiciable controversy. I have challenged whether the just cause was properly determined, which would go to justiciable controversy, because if at any time there is no justiciable controversy, the matter is moot. They are required, Chief Disciplinary Counsel is required, after they make an initial assessment of the complaint, they are required to conduct a thorough investigation before they have just cause. Just cause a thorough investigation would have revealed that there was a gap between the date the complaint was filed, which was in May, and the date of the actual judgment, because the earlier judgment on which the complaint was based was withdrawn, and the evidence shows, and it's in the brief, that it was declared void. So, and void means it never was valid.
Well, the Court of Appeal did not use the word void. They said we withdraw on our own motion to determine en banc the principles to be used for assessing sanctions for frivolous appeals. That's what they said, was it
I
not?
believe the word void is at the top, but I'm not absolutely certain. I'd have to look at that page, but it definitely says it is withdrawn,
Is
of no
withdrawn was the
force
word.
and effect.
But the substantive challenge in the disciplinary proceeding dealt with your choice of briefing in the appeal, did it not?
My choice of briefing.
3.01 and 3.02 dealt with assertions that in your choices of the briefing on that appeal, you had chosen frivolous issues and the allegation under 302 that you had excessively multiplied proceedings.
3.01, the language has to do with what I reasonably have believed. Now, the 14th court concluded, without addressing the proper issues, that I could not have believed that. And it even says, I knew they had jurisdiction. I can't know that. A court has to determine that. I can't know anything until it's before the court with facts and admissible evidence.
The 14th court looked at older cases that had a subjective element and an objective element.
They
and
did not
determined
cite
that
other
under
cases.
that was the purpose for the en banc proceeding, was to deal with discrepancies in prior cases, was it not?
No, I don't know what the purpose was of the en banc proceedings. They acknowledged Dubai. They acknowledged that there was no proof of jurisdiction. What they did not address, was that the all of these cases that deal with the standards of Department of Parks and Wildlife originate in district court. It says nothing about any of the other agencies, such as the state bar, nothing about statutory courts. And to change that would be a massive change in the consistent history in this state that draws a clear distinction between district courts, our courts of general jurisdiction created by the state constitution, and our statutory courts. That's one of the main distinctions, is that you go into district court in the Department of Parks and Wildlife. You go into district court, and the presumption, because it is a court of general jurisdiction, is that it has jurisdiction. However, if you were to go into district court on a forcible entry and detainer, even if everyone agrees, that court has no jurisdiction. Those are the exclusive province of justice courts. So it wouldn't matter what they did, they wouldn't have jurisdiction. Jurisdiction is a question of law, and it has to be established. The case law is clear. It is the specific burden of the petitioner. It cannot be shifted. It cannot be waived. It cannot be granted by estoppel. It cannot be conferred. It was not achieved here. Have I answered your question?
You've answered. Go ahead.
The last one, we're somewhat over time, but I understand that some questions have interrupted your presentation. I'll give you a few more minutes, but please be mindful of the parties that are behind you on the docket.
I am aware of that.
Thank you.
There is an evidentiary panel proceedings procedural guide. As best I could tell, no one in the Houston office was aware of that, and it has specific requirements for conducting these procedures. The reason it came up is the question of recusal. When I asked about the internal rules, I was told there are none. And I have that email that's in evidence that says there are none. That was sent by Assistant Disciplinary Counsel. In fact, they've been published annually by the Chief Disciplinary Counsel, or the Office of Chief Disciplinary Counsel, at the instruction of the State Bar, and they're supposed to be distributed to each and every member of the grievance committee. They are also supposed to have annual training. From the language in
Did we find out what she did yet? Now the prosecutor hasn't gone up yet. I understand that. Did we find out what she did wrong yet?
The transcript, it's fairly obvious. And some of them actually acknowledged they had no knowledge of the State Bar Board policy manuals that set forth how the grievance committees are to be conducted. And they had no knowledge of these manuals. And it was important for recusal because they originally had the panel assigned handling it, the challenge to recusal of that same panel. And that panel told me they knew of no other rules or procedures.
Let me ask you this question, Ms. Glassman. As I understand this complaint, it related to the filing of a frivolous pleading, correct?
It related to their conclusion that it was frivolous,
There was a conclusion by the Court of Appeals
that it was frivolous.
that it was frivolous. Can you address the question of whether the conclusion by the 14th Court of Appeals that your pleading was frivolous amounts to a judicial finding that the pleading was frivolous?
It can only be a judicial finding if it's predicated on proper evidence and support. It is not.
Are you challenging the jurisdiction of the 14th Court of Appeals to make that determination?
No, I'm saying that they didn't make it properly.
Now, if the 14th Court of Appeals made that determination and an evidentiary panel found that to be persuasive among other evidence that it might have considered, do you agree that the standard of review here before this board is a substantial evidence review?
Well, actually, the standard of review here has to do with jurisdiction, which may be raised at any time and must be, the record must be reviewed by you to see if there is, if subject matter jurisdiction has been established.
I'm simply trying to narrow the issues. Do you agree that the finding of the 14th Court of Appeals that your pleading was frivolous could be binding in the sense that it's a judicial finding and as such would support a finding of the evidentiary panel that you had filed a frivolous pleading?
No, I presented case law pointing out that an opinion of a court is not binding. 3.01, frivolous doesn't have anything to do with my beliefs. And the burden of proof is on the Commission for Lawyer Discipline. And that's 2.17 of the Texas Rules of Disciplinary Procedure. And all presumptions are in my favor.
Does the court's finding amount to evidence upon which a reasonable person might find that you had filed a frivolous pleading?
It would meet the first investigation standard. It would not meet the thorough investigation standard.
All right, proceed.
Well, I'm going to move on since I don't know where I am in time.
Well, you have your rebuttal time left, so.
Well, I would like to address the rendition question.
All right.
Their evidentiary hearing report does not show that there were deliberations, does not show the presence of a quorum. And there is an instruction on page 3 that the office of whoever prepares the judgments is to prepare a judgment that is consistent with the evidentiary hearing report. That judgment is not consistent with it. Case law is quite clear and there are no exceptions. The first statement
Thank you, Monica. Thank you. Thank you.
There was no oral rendition. This is the evidentiary hearing report is the rendition and it is void on its face. The only case that deals with, only cases from Board of Disciplinary Appeals that deal with rendition deal with whether a quorum was present the entire time. There are no cases that deal with no indication of a quorum and no indication of deliberations. And they do not, findings of fact are supposed to be connected to the evidence. That is not done because there was no evidence. I didn't get to cover everything, obviously, but I think I've run out of time and I do get a few minutes for rebuttal. Thank you very much for your attention.
Ms. Hamilton.
Mel, they can see it right here.
Good morning.
They can see it right here.
Ms. Glassman was disbarred because she failed to put on any meaningful defense to serious allegations of misconduct, and those allegations were well supported by the evidence that the commission offered. This board should affirm the judgment because in this appeal, Ms. Glassman's complaints are based entirely on issues that aren't supported by the law or by the record. In my argument, I want to first focus briefly on the different subparts to Ms. Glassman's arguments regarding jurisdiction, and then just touch on the evidence and the sufficiency of that evidence to support the judgment of disbarment. Obviously, Ms. Glassman's main complaint has to do with jurisdiction. There are several sort of subparts to that argument. The main one appears to be that this reliance on the fact that the Court of Appeals did withdraw its opinion at some point. And it's not disputed, yes, the Court of Appeals withdrew the opinion that it originally issued in February. All of these events regarding the opinion took place in 2011. Now in February, the Court of Appeals first affirmed the decision against Ms. Glassman and rendered an opinion, a decision against her. Then a few months later in May, the complainant in this disciplinary case signed the grievance that was filed with the state bar. The Chief Disciplinary Counsel's office actually received that grievance more than a month later, more than a month after it was signed. And in the interim of that period of about, not quite a month, about 3 weeks, the Court of Appeals withdrew its opinion and in its stead issued a new opinion, an en banc opinion. When the Court of Appeals did that, it explained what it was doing and said that it was denying Ms. Glassman's motion for rehearing and her motion for en banc reconsideration. It was withdrawing its previous memorandum opinion, and it was issuing a new en banc opinion. And I'm quoting from the court's decision. It said, on its own motion, this court grants en banc rehearing to secure uniformity in this court's precedent regarding the legal standard for imposing sanctions under Texas Rule of Appellate Procedure 45. So what the court did was it decided that this case was important enough and this issue was important enough that it was going to use this case to establish precedent by the en banc Court of Appeals. It took that step because it felt so strongly about the decision that it was making. Now, Ms. Glassman says that because the Court of Appeals withdrew its opinion and issued this new opinion, that the complaint became moot. The grievance that was filed against her became moot. And because of that, everything that came later then was void because the panel could not have acquired subject matter jurisdiction over this complaint. I think that argument is obviously unreasonable and illogical. The word void has been used to describe the original decision of the Court of Appeals. Ms. Glassman claims that for some reason that judgment, that opinion became void, and so that rendered the grievance moot. There was no longer a justiciable controversy. That argument just makes no sense. It's illogical. This grievance proceeding is based on Ms. Glassman's actions. Yes, the Court of Appeals opinion is evidence and very strong evidence of her misconduct and what happened here, her actions that violated the disciplinary rules. But even if for that their opinion ceased to exist at some point in time, which just is not borne out by the record or the law, even assuming that it did cease to exist, that would not have robbed the evidentiary panel of jurisdiction over this grievance. Which takes us to Ms. Glassman's the second point in her argument regarding jurisdiction. She's focused heavily on an argument that it was necessary for the commission to plead and prove all of the elements of jurisdiction because this proceeding was in an administrative agency. She's essentially asserting that in order for this panel to have had jurisdiction, the commission had to plead and prove the satisfaction of every procedural step that's set forth in the State Bar Act, the Texas Rules of Disciplinary Procedure, all policy and procedural manuals that have anything to do with evidentiary proceedings or with State Bar committees. And she even mentions the Texas Rules of Civil Procedure. I think I've captured most of the sources that she identifies, maybe not every single one. There was some mention of the Texas Rules of Evidence as well. And so her position is that the commission had to put in its disciplinary petition, allege that every single one of these requirements was satisfied, and then put on proof to support that allegation. This argument, too, does not logically make sense because it would serve no meaningful purpose for the commission to do that. There's also no law to support this argument. And if you look at the law that does govern what has to be included in an evidentiary petition, which is Rule 2.17A of the Rules of Disciplinary Procedure, it sets forth the required contents of a petition. If we look at this petition on its face, it looks like it complied with that requirement. There's no evidence anywhere to show that the petition didn't comply. In response to Ms. Glassman's jurisdictional pleas, the commission's counsel went to great lengths. He filed a response that was over 100 pages to show.
I looked it up, en blanc, whatever she was saying, en banc. Okay, so when the lady first went in front of the panel of judges, they weren't all there, and they made a decision, and they gave their written opinion. Well, then her case was brought, like, all of the judges looked at the transcripts. All of the judges got together and said, wait a second, we got to fix this. So it just means that, here, I'll show you. This is what I found out. So that all of the judges decided we all need to have our own opinion on this, and gave a second opinion, a different opinion, a replacement opinion.
That all of the relevant procedural requirements that Ms. Glassman seemed to be complaining about had been satisfied. So there's just nothing in the record to support this argument. In addition, a very important point in response to this argument is that even if the record did bear out Ms. Glassman's complaint, even if the record showed that somewhere somebody had failed to comply with one of these requirements set forth in any of these areas, whether it was the commission or if it was the evidentiary panel that failed to comply, that there's nothing to support that such a failure would have deprived the evidentiary panel of jurisdiction. A case that has been discussed in this appeal is the Dubai Petroleum case, which is an important case in Texas jurisprudence. But it's important for a principle that undercuts Ms. Glassman's entire appeal, and that has to do with jurisdictional prerequisites. And what the Dubai case did was it represented the Texas Supreme Court taking a position that veered from a position that it had previously taken with regard to jurisdictional prerequisites. And the court decided and explains this.
A quorum is the absolute minimum you can have. So en banc would be all of them, the most you can have.
Very clearly in the Dubai opinion that judgments should not easily be subject to collateral attack based on complaints about subject matter jurisdiction. And I shouldn't even use the word collateral attack. The court just said judgments should not be vulnerable based on complaints about subject matter jurisdiction. And so the failure to satisfy different kinds of statutory prerequisites should not easily cause a tribunal to be deprived of jurisdiction. And the Dubai case and the line of cases that has followed it, and still persists to this day, the Supreme Court continues to follow this line of cases. And that the Dubai case was issued in 2000 by the Texas Supreme Court. Those cases, that the basic premises that they stand for is that statutory prerequisites are presumed to be non-jurisdictional unless there's clear legislative intent to the contrary. And we have in this appeal nothing of that nature. No requirement that has been identified that first was not followed, and second, that was jurisdictional. So again, even if the commission or the panel had failed to satisfy one of these requirements, the presumption would be that it's not jurisdictional, and so the panel would not have been robbed of jurisdiction. And the third point that I want to discuss that Ms. Glassman makes has to do with voidness. And this is a pretty simple argument, and that is that everything that flows from a void judgment is void. And she says that everything in this case flowed from a void judgment. The problem with that argument is that all Ms. Glassman uses to support that argument is basically her own conclusory assertion that the original decision of the probate court was void. She's made this argument repeatedly. It's been repeatedly rejected. Again, the Court of Appeals, the 14th Court of Appeals, took very unusual steps in addressing this argument by Ms. Glassman and really refuting any notion that there was any validity to the argument. Finally, the fourth point in this jurisdictional argument, and I say this is the fourth point, really I tried to organize this argument into categories in order to give some sense of organization to my response brief. So I say this is the fourth point. It's not necessarily the fourth point that Ms. Glassman brought up, but the fourth point in the argument that she was making in the order that I wanted to address them. So the final remaining issue that she mentions has to do with fair notice. And in this case, looking at the petition, looking at the evidence that was offered by the commission, looking at reading the reporter's record from the evidentiary hearing, there is no question that Ms. Glassman had fair notice of the allegations that the commission was making against her from the inception of this disciplinary proceeding. The Texas standard for fair notice says that a pleading is sufficient if the opposing party can ascertain from the pleading the nature and basic issues of the controversy and the type of evidence that might be relevant. In this case, the live petition had a 5-paragraph detailed summary of the factual allegations that the commission was asserting. It described the unsuccessful probate dispute between Ms. Glassman and her sister and the subsequent garnishment order that her sister obtained. It talked about the appeal that was filed by Ms. Glassman and the Court of Appeals decision to impose sanctions for.
What does her sister have to do with anything? I missed that completely.
What it decided was a frivolous appeal, and it identified the 2 specific rules that allegedly were violated. Now, this information was sufficient to let Ms. Glassman know what the commission's allegations were, the factual nature of those allegations, what laws the commission was talking about, the 2 specific rules, and let her know that what happened in this appeal in the 14th Court of Appeals and all of the actions leading up to that appeal, those were the issues that were going to be relevant to the charges against her. Her failure to offer any evidence in defense of those allegations could not have been because she wasn't on notice of what they were. So those are the main points that Ms. Glassman makes in attacking this judgment. Now, as I've stated in the commission's brief, she provides a very long list of different complaints, but those are the 4 categories that they seem to all fit into. None of those arguments, none of those complaints has any merit. That's why this judgment should be affirmed, but it should also be affirmed for an additional reason. And that is that the evidence in this case of Ms. Glassman's misconduct is more than sufficient to support the judgment. We have a Court of Appeals en banc opinion. That standing alone is sufficient to support the judgment. The court held that Ms. Glassman filed an appeal under circumstances where, and I'm going to quote what they say in the opinion, she had no reasonable grounds to believe that the case could be reversed. And the court also found that it took an unusual step of imposing sanctions against her. That doesn't happen often in the Court of Appeals.
How often does that happen in a Court of Appeals?
I can't tell you specifically, but I did some research on this topic just a few months ago in connection with a presentation I made at a
Thank
CLE,
you for the root of
at a
evil.
CLE conference.
Thank you,
and
Dwight.
It's
Thank
very
you.
difficult to find a Court of Appeals opinion, a Court of Appeals decision imposing sanctions for a frivolous appeal, and especially one that goes into great detail about why sanctions are so important, as the Court of Appeals did in this case. Now, this Court of Appeals opinion appears to be establishing pretty important precedent for appellate sanctions in the state of Texas. The Court of Appeals found that sanctions were justified for a very specific reason and explained that in its opinion. It said that Ms. Glassman explicitly took one position in order to advance her claims in the trial court, in the probate court, and then subsequently took the opposite position on appeal. So that supported the Court of Appeals' determination that her appeal lacked any reasonable
Kelly,
foundation.
thank you, thank you,
And so
thank
they
you.
decided that, again, they would take the unusual step of imposing significant monetary sanctions.
So I take it it's your position that if the commission had showed up at the hearing in the grievance committee and given the panel members a copy of the 14th opinion, could have rested at that point essentially?
Yes, they could have, but the commission did not do that. The commission brought in a witness who was very knowledgeable about what happened in this case because he was opposing counsel in the probate proceedings up through the appeal to the 14th Court of Appeals. And he described in great detail what happened and why it was that he had filed the grievance complaining that Ms. Glassman acted unreasonably and violated the disciplinary rules. So we have the Court of Appeals, which is very solid support for the judgment. And then on top of that, we also have Attorney Faison's testimony. And so because the judgment is so well supported by the evidence that the commission offered, the evidence of record in this case, and in addition, the issues that Ms. Glassman raises don't find any support in the record or in the law, the commission urges the board to affirm this disbarment in all respects.
I have a question, Ms. Hamilton. At any point did the commission consider something less than disbarment?
That's not a question I can answer. That's just not something that is in the record. And often I might know the answer to that question, but in this case, I did not look at
I know the answer.
information regarding
I
potential
do.
settlement talks.
Did the record reflect the prior
All right, maybe. So I know that she was partially probated, suspended twice in her career before this. One was in 1998. The other was in 2009. So that 2009 could have been the first step of all. I don't know. This is old. This is an old case. I'm like 11 years ago or something crazy like that. So she could have gotten suspended first, or she got suspended for a completely different other thing.
discipline? Was that also based on 301 or 3.01 and 3.02?
Yes, the record did include the prior disciplinary judgment, and I am going to demonstrate the limitations of my brain power, and I have reached it in this case. And I believe it was the same. It may not have been both rules, but I cannot remember specifically.
Okay.
But it is in the record, and it is something that I could easily look up and give you information about.
You know, Ms. Hamilton, does the commission have a particular policy or standard that they use when you have a violation of 3.01 or 3.02, the range of punishment, or I don't like the word punishment. But
Taser.
Come up with
Sanctions,
something.
right?
Sanction, please.
No, there is no set guideline regarding that particular rule. I will say that in the cases, and I don't think that this is a frequent source of a disciplinary case, these particular rules, but in the cases that I have seen that involve these rules, I think there can be a pretty broad range of misconduct that could fit under the rule. So there could be a pretty broad range of appropriate sanctions. It's hard to determine exactly why a case results in disbarment, but in this case, when you look at the record, you see how similar the conduct is in this case to the previous disciplinary case where Ms. Glassman received a very lengthy suspension from the practice of law. And while she was suspended, continued to engage in the kind of conduct that led to her suspension, and then went to the evidentiary panel and never really put on any meaningful defense, but instead continued to persist with the kinds of arguments that had no reasonable basis and had not succeeded in any court or even before the previous evidentiary panel. That kind of conduct led to a very easily supportable conclusion that her continuation as a licensed attorney wouldn't be in the public's interest.
Ms. Hamilton, putting aside the jurisdictional arguments for the moment, is there?
I wanted to wait till the end, but I can't. I gotta show you guys this. So what this she's saying fits better. She's disbarred. She was disbarred in 2013. So now you know the end of this. You already know the answer. You already know the verdict. But here's what happened in her lawyer career. So she got suspended in 1998, okay? And there was a sanction in place from 1998, August, to July. So 1 year. 1 year. Okay? Then, after that sanction was over, she was on probation. So what I'm guessing, and I could be wrong, what I'm guessing is she wasn't allowed to practice during the sanction. And then at the end of the sanction, she was put on probation. So she was allowed to practice. This probation lasted from 1999 to 2006. Damn. Okay, she completes her probation. She's practicing again in 2009. All right, when she gets suspended again. The sanction started in 2000 in March and ended in 2011. So I'm sure, I don't know, that she was not allowed to practice law between 2009 and 2011. But then she was put on probation from 2011 to 2019. Except it looks like what happened was she took this to the appeals and everything, and boom, disbarred in 2013. And she is still, see this little red square? That means she's disbarred. Well, it means she's not a lawyer anymore. It doesn't mean she's disbarred. She is disbarred, but there's lots of reasons why people aren't lawyers anymore. But she's not eligible to practice in Texas because she is disbarred. That was going to be the end of the video, but too late now.
I can't remember any assertion in the record or in the briefs that our review is other than standard substantial evidence review. Do you agree with that, or am I mistaken?
That's correct.
Nobody's even arguing that, other than the jurisdictional cluster of arguments.
That's correct.
Thank you.
Any other questions? Thank you, Ms. Hamilton.
Thank you.
Glassman, we have burned through quite a bit of time, but we'll give you additional 3 minutes to rebut anything that Ms. Hamilton said. Yes, ma'am.
Well, let's start with Ms. Hamilton has mischaracterized what happened. Just cause is only one element of jurisdiction. Imagine yourselves going into a dark room. You have to turn on the lights. The panel was not deprived or robbed of jurisdiction. They never acquired it. And there is a distinction. In order to have it, there has to be proof of subject matter jurisdiction. And that's acknowledged in the record. They tried, they just couldn't do it. The question about being moot.
I don't follow. As to the just cause, why was the 14th court's opinion not just cause? Why was not the 5 years of prior litigation just cause? Why was your contempt jailing not just cause? For a 301 and a 302.
Yo, she went to jail. she went to jail for contempt of court. What?
Petition.
This problem began with a disregard by Judge Austin of all of my rights. The contempt, He had no jurisdiction to order contempt. That didn't stop him.
No,
He had-
your view is he did not, but on its face, why were those things not sufficient just cause? I don't understand your suggestion that there was no just cause.
Because Chief Disciplinary Counsel must conduct a thorough investigation, and the thorough investigation would show that there was a point where the case was moot. And that is supported in the NCAA case, which is cited in my brief. That
Ms.
there is
Glassman,
any point.
I don't know, I don't mean to step on Mr. McKetta's question, but I may be here. Once, I understand the procedure being that there needs to be an investigation, and if the commission finds just cause, it proceeds. But once it says it's found just cause, it starts all over again, doesn't it?
And then they have to prove.
I understand that.
And they didn't.
Well,
And they didn't.
whether in your mind, just cause was actually found by the commission, such as it was necessary to proceed, sort of, it to me seems irrelevant as long as they went through the process. Because again, they're having to prove their case de novo in effect, once they get it before a grievance
And
committee.
that's what they did not do.
Well, that's another matter, it seems to me. That is there enough evidence to support what the grievance committee did? I get that.
Thank you.
But I don't understand the just cause finding being that important once you get past there.
To me, it was not that important.
Thank
Ms.
you.
Hamilton has presented it as important in order to glide over the rest of subject matter jurisdiction.
Thank you. That's what he
And
needed
she
to hear.
repeatedly talks about robbing or depriving jurisdiction. It's not a matter of taking away something that existed. It never reached the standard of existing.
Right, thank
Every
you.
procedural, she dismisses all the procedural steps. Procedural steps are due process. That's what the 14th Amendment and the Texas Constitution are all about. I'm entitled to have the procedures followed. I'm entitled to have a panel that's properly trained and supervised. I'm entitled to have factual information. Reciting the rules that they claim I have violated does not say anything about what's in my mind, and that's what the rule says specifically.
No, it does
Did
not.
I believe?
No, it does not. It talks.
That's why she was disbarred. She was trying to give away what's in her mind. She was disbarred. Jail, taser.
About a reasonable belief. And no
Right.
matter
It talks
what you
about
believe,
a reasonable belief and whether or not there was a reasonable belief. I have pointed out that there are no cases anywhere that change this fundamental requirement of proving subject matter jurisdiction in order to activate the authority of a tribunal, an administrative agency. Let's separate the 14th Court. The evidentiary proceeding did not follow any of the fundamental criteria for due process.
All right, I appreciate your argument, Ms. Glassman. We will take this matter under advisement and notify the parties of our decision. We're going to take a
Well, I already told you the answer. Now I have nothing to tell you no more. She got disbarred, guys. She's not a practicing lawyer anymore. I wonder what she does with her life. She spent all that money on law school. Now, most likely she had already paid off her loans because she seemed, they said she was 71 years old by the time that hearing took place. So she was done working anyway, you know? She's probably retired. Well, I'm glad Victoria's didn't work. No one could hear Victoria's because that lady was more fun. I don't know. Victoria had a great accent, and she was also pro se, so that one probably would have been fun too. Guys, thank you so much for coming out today. I really appreciate it. I'll see you all in OJ in a few minutes. Bye, guys.
Got these just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's love.